Thank you. So today, as you just heard, I'm going to touch on software patents in the U.S. One of my table mates, when I told him what my topic was this morning, he immediately asked, "They still make those?" And the answer is perhaps. So we're going to go over a few things. I'd like to sort of get a historical timeline so we can sort of get an understanding of how we got to where we are with regard to software patents and eligibility. Then we'll talk about remind ourselves what software is and what types of ways we can protect software. And then we'll dive into some common challenges that software patents encounter, both at the PTO and in litigation. And then finally, we'll go over some survival techniques that can potentially help. So what's the history of business method patents? In the late 90s, there was a case called State Street Bank that really sort of changed the dynamic with regard to the way people thought about business methods. It found a patent that dealt with the pooling of assets of mutual funds eligible, and the language in the case was very broad. The finding was just that the invention just needed to produce a tangible and concrete result. And what we kind of saw after that was a spike in filings of business method patent applications, as well as due to a certain extent patent search tools not being fully useful in examining those types of cases, patent grants. This also coincides with the entry of the internet into our daily lives to a way that we can never, it's difficult to remember a time without the internet now. And so this chart here is basically the percentage of total applications filed each year that were classified in the 705 classification, which is typically where business methods might be filed, and were actually ultimately patented. So you can see, just sort of in the late 90s, there was a fairly significant spike in the filing of business method patents. So right around this time period, the late 90s, early 2000s, there was the infamous dot-com bubble that burst, and also the promulgation or the evolution of non-practicing entities, or what some would call patent trolls. And so a lot of patents were being bought up and being used in litigation or threatened litigation to extract revenue. And so a lot of industries that weren't used to being involved in patent infringement were finding themselves involved in patent infringement, and a lot of, let's say, angst or upset folks in a number of industries began to raise their concerns. And, whoops, did I go? Oh, no, here we go. And so here's some examples of what was going on: hedging risks in commodities trading, electronic escrow service. That's actually in 2014. But usually the outrage is based on the newness of it. You know, people have been doing this for years. This is not new. Why did they get a patent on this? But as I mentioned, the patents were being granted because oftentimes the examiners were not aware of or not privy to certain prior art. So now let's talk about software, which is why we're here, okay? And so just to remind ourselves what software is, it's essentially data and instructions in data. This portion over here is what humans create. It's either high-level source code at C++ or Python language, or a low-level assembly language that gets compiled. This code gets compiled into some binary code that's machine-readable by a typical computer. We can also talk about the purpose of software. What's the purpose? This is a typical software stack with sort of levels of abstraction going from, this is more detailed into less detailed, where we can see, oftentimes the business method aspect can be found at the higher application layer, where that's what the end user sees and interfaces with. Another thing to think about is what this software typically embodied in. These are all different sort of forms that we can find software: hard disk drive, RAM, random access memory, CD, EEPROM, electrically programmable read-only memory, solid-state drive, flash drives. These are all things that we can sort of envision. We all have something like this in our possession probably right now. It can also be embodied in a propagated signal, where when you get a software, when you get an upgrade to your iPhone, that's coming over the air. That's a new program update, code being installed on your device through electronic transmissions. Just a point that this will come up a little bit later is software can also sort of be embodied in other types of technology, some that we can call configurable logic. This is called, one example would be field programmable gate array. It's where you have a chip, and then once you apply an electromagnetic field to it, it programs the chip to perform certain operations. And then fixed functionality hardware logic is more fixed. When you when you create the chip performs these functions in a certain way every time that you operate it. An example is this is an application-specific integrated circuit. So instructions can actually be, there's an instruction set architecture that's native to the chip that often can be considered arguably instructions. There's also configuration data and state setting data for the circuitry. Now, what are some common challenges that we encounter to software-related inventions? Section 101 of the U.S. Patent Code is the one that deals with patent eligibility. You may have heard about the Alice case that took place not too long ago. And the finding of that is that there's a two-step analysis that should be applied. The first step is whether or not the claims are drawn to a patent-ineligible concept. And there are three listed here: the laws of nature, natural phenomena, and abstract idea. We're focused mostly on abstract idea because we encounter that the most often with regard to software-related inventions. I would point out that this is a somewhat circular analysis here because we're trying to find out if something is patent eligible, and the first thing we say is it's drawn to something that's patent ineligible. It's not particularly helpful. But the second step is meant to sort of, I believe, meant to lend some assistance or guidance, and that is to whether or not there's an inventive concept that transforms a claim into something that's patent eligible. Now, I've highlighted inventive concept here because this is typically a prior art question. What something is inventive is it's new and non-obvious. We already have code that deals with that. It's called Section 102 and 103. It's peculiar to me that this is part of the analysis, but actually I have a slide here that goes into some detail as to why that is. I tracked down the lineage of the term abstract idea. It was it's used in Alice, but it can be traced all the way back to the 1800s to a couple Supreme Court cases. You can see in this rubber tip pencil case, they talked about everyone knew the idea when they're talking about whether something's abstract. And this case, they talk about something, whether or not it was previously unknown. The point of this is patentability and patent eligibility have been intertwined for a very long time. And so while I'm not a real fan of the analysis, it's going to take a lot of work to extract those two concepts. So some other challenges we see are, and this is typically in the patent office, something is being characterized as software per se, and in particular the term module in claims is being interpreted as being software and therefore per se unpatentable. However, there's a lot of problems with this analysis, and that is, just one example is the Enfish case from the Federal Circuit last year. There's quite a bit of language in there that makes it clear that just because something is software does not mean it's an abstract concept. Another challenge we see is that it's implemented in a propagated signal. Remember I mentioned about the transmissions between the transmitter and the receiver. Basis for that case is the Nugent case from 2007. Here's a somewhat recent development, is a lot more emphasis on means plus function interpretation. And that is when you claim something functionally, there is a portion of the U.S. code that dictates that they determine that to be means plus function interpretation, means plus function language, and they look to the specification to see what structure is provided in the specification to support those functions. And a big problem is if, where there's two issues, even if you try to avoid means plus function interpretation, there's a Williamson case in 2005 that said if you take just taking the word means out of your claim does not necessarily mean get you out of means plus function interpretation. They call that replacing means with a nonce word. And more important, I would say, more important development is, or aspect of this is, if there is not sufficient structure in the specification, you can get an indefinite rejection that can actually render the patent invalid. And in this particular case, Williamson, there was no flow chart to support the functional algorithm, and that essentially killed the patent. All right, so those are some issues, challenges that we are presented with on a regular basis. Let's talk about some survival techniques. In essence, this is what I'm advocating, and that is to just keep your software from being brushed into the business method bucket. A lot of the angst and sort of drive behind patent quality and patent analyzing whether or not, deciding whether or not, debating over whether or not a patent should have been granted is driven out of the business method developments. But software patents and software-related technology is being sort of lumped in and oftentimes with the business method situation. So here are some tips that I would provide, that I would suggest. One is to describe a technological problem in this specification. Now, there is some risk associated with that, and one issue to keep in mind is where you put it. In these two cases, Macro and Bascom, there was the courts relied heavily on statements made in the background section with regard to the prior art. But there's a risk of anything you put in, actually anything in your application can be cited against you as applicant admitted prior art instead of an actual reference. And so, a practice that I typically use is, I'm a waffler. Everything is either may or illustrated as a safety measure. But this is proved to be very helpful in some cases with regard to determining how, what was the prior, what was the problem that there, this establishing that there was a technological problem. Another tactic that I've been using is using the word technology and equivalence thereof. I use it freely throughout the specification in the abstract, even in the title. Often you'll see a patent application start off with method, system, apparatus for. Actually, that's not really helpful from an administrative standpoint or substantive standpoint, because if every application starts off with that, you're halfway through the title before you even know what the thing is about. So another thing that I suggest is to there's a hook, there's a point of novelty or an ordered combination of elements. Whatever it is, it's like your elevator pitch for your invention. Why are we filing this? Why is this important? What's so special? Recite that. Make sure that's recited in your claims and make it sound as technological as possible. What the courts are essentially going to be looking for is an unconventional solution, technological solution to a technological problem. And so here are some examples of the handful of successful software-related cases that have successfully survived an patent ineligibility challenge. We can see a graphical user interface, self-referential database, distributed networking, based content filters, phoneme sequence of rules to determine and output morph weight set system, distributed networking. We can see two cases where distributed networking was persuasive, composite web page generation. And so the idea is to make sure your claims really recite and establish what you believe to be the point of novelty and non-obviousness. And also remember to characterize it as providing an improvement. It's great to be different from what the prior art is, but there needs to be there's a so what behind that. So what? And in particular, NFISH was a good example of where the courts found that there was faster searching, more effective storage of data, more flexibility with regard to a self-referential database. Another thing that sometimes gets overlooked is what claims you select. What claims do you decide to put into an application? One thing that sometimes people is confirm that you're actually dealing with something it's based in software. Maybe it's not. Maybe it's more likely to be implemented in the configurable logic or fixed functionality logic hardware. And that, if that's the case, I mean, and there are situations where that would happen. Is the reason why we do fixed functionality logic hardware is because it's faster. They call them accelerators. And software is great because it's programmable, but it's not as fast. So if we're pretty certain that this particular technology, maybe it's in the memory sector or something particular about that technology that would say this is not going to be it's actually not going to be what's considered traditional software. Maybe you should try a different approach where we're just claiming a chip that has a substrate and logic coupled to the substrate and clarify that it's implemented in configurable fixed functionality logic hardware. It's hard to say that this is not structure, that this is not a technological advancement. Now, what you recite after this are probably basically your functions, and but then then you get into the debate over whether or not that's abstract or whether or not that is new in view of what's already been done. But we're happy to have that debate. I'd like to take the focus back on patentability and what does the prior art say, what does it show, and what are we claiming? And are we claiming something that's not in the prior art? That's where I would love for the discussion to return to, as opposed to all of these disputes over whether or not something is an abstract idea. Another thing to think about is what language you use in the application, both in the claims and in the specification. I think almost every application I've ever read uses some type of for determining, I've essentially taken that out of my vocabulary unless that's what I'm trying to do. And so instead of saying means for determining, you could say logic to determine. Some would say, well, replace means with determiner, determiner for determining, but you're going to get Williamson concerns with regard to that being just a nonce being used in exchange for the word means. And so this is just going back to the chip claim technique that I mentioned earlier. And I use this throughout the application, not just in the claims. Another consideration is what do you do about your method claims? You could put structure in your method claims, although that sort of defeats the purpose of method claims. However, generally speaking, method claims are not as valuable in infringement and licensing because in order to infringe those claims, the device needs to be operating, and if you're in a battle with a competitor, you're at risk of suing your clients. And so here's one case, the SURF Federal Circuit case back in 2010, where the recitation of a GPS receiver in the claims was persuasive, and it helped the claims be deemed eligible. Okay, so also you know, a lot of those topics were about what to do when you're drafting a case. Sometimes you don't have that luxury. If you have an application that you're prosecuting, you're dealing with examiner rejections with regard to eligibility. For the reasons we talked about before, go ahead and incorporate patentability arguments into your eligibility traversal. In other words, you know, as we mentioned later in this response, this is also this is not novel and non-obvious. And actually, when you're dealing with examiners, when you're conducting an examiner interview, I advocate to discuss the patentability rejections before you even talk about the eligibility rejections, because oftentimes if you resolve that, the eligibility question becomes, it sort of shrinks in the case. One important thing is to, if you get an abstract idea rejection, really make sure that it's clear what the abstract idea is deemed to be. Earlier in the wake of Alice, we saw several office actions that would just say an abstract idea, and they would not articulate what the abstract idea was. So it's very helpful. It can be very helpful to get some clarification as to what we believe this abstract idea is, because then that actually gives you some potential leverage with regard to the remaining features in the claim, by using an argument that there is no preemption. So in other words, we're not preempting this abstract idea because we have all these other features recited in the claim, and so that's often helpful as far as an argument. And then you can also argue that the claim solution is tied to a particular machine or involves transformations. This goes back to the machine plus transformation test. It's not supposed to be dispositive, but it is often helpful. Thanks.